Sure.
We're live.
Hey, we are back in Senate Judiciary on February 26th. We have the bill that keeps on giving, S12. And I think we're getting pretty close to the end. Fingers crossed. And we have Michelle from Ledge Council to provide us a walkthrough of some of the new changes that we have provided.
So for the record, Michelle Child's Office of Legislative Counsel, and we're working off draft 4.2. So you may be saying, wait, did I miss some of these drafts or whatever? So there've been a lot of drafts that have happened since the last time we did a walkthrough, and there was a draft last week that was done in the threes that you didn't actually walk through, so we've kind of moved along. So you're not missing anything, and anything that is different from what you had last seen is still highlighted. I think you've already made most of these decisions, but I didn't want folks to lose track of them. So the first change is on page 5, and this is with regard to qualifying offenses. And I just kept this highlighted because it was new in the last draft, which was for misdemeanors. It's all misdemeanors except a certain list, and on the list now is any offense that would require education as a substance offense. The next change is on page 7, and just I'm changing the title here. So on line 21, in previous versions, expungement had been struck because you were eliminating any option for expungement and just moving to sealing. However, you made a policy decision last time that for offenses that are no longer crimes, that those records would be expunged and not sealed. And so I just had to change the title there. And all the way to page 14. This is the petition for sealing or expungement. You'll see the new language starts on line 20. So a person may file a petition with the court requesting expungement of a criminal history record related to conviction if the person was convicted for an offense for which the underlying conduct is no longer prohibited by law, designated as a criminal offense. So that is the one under this provision that we carved out. That's going to be expungement, but everything else would be sealing unless it's specifically designated later on, because you did decide to revert back to expungement for deferreds.
Correct. That was RAT's number 1. Mm-hmm. Yeah. Okay.
So I just had to renumber those subdivisions. There's just little technicals and cross references that I have highlighted there, or you'll see the new language. If you look at the bottom of page 15 for subsection B, this is on the petitions filed if it's no longer a crime. So if you change the top of page 16 from sealing to expungement. And then the changes in C and D are just changing the cross references because I had to reorganize it a little bit. Same on subsection E. Now we're going to get to the section 7607, which is the effective sealing, and we're getting to the real tough stuff that folks have been grappling with on the access to sealed records. So intro language starts on page 24, subsection C. Page 25 is the I had struck, and I should have struck it in an earlier version. I just forgotten, but struck the 10-year period. Remember the super sealing bit, you had made a policy decision to eliminate that. And then you have new language around law enforcement access. So the new subdivision 2, it's divided into criminal justice agencies and then for a defense attorney. So criminal justice agency and the Attorney General may apply for an inquest pursuant to our existing inquest chapter for the purpose of accessing sealed criminal history record, provided reasonable suspicion exists that the sealed record contains information that will aid in solving a crime or apprehending a suspect. So linking into the existing process. Subdivision 2 is for in case of a defense attorney. Defense attorney can file a petition with the court for the purpose of accessing a sealed criminal history record, and the court would hold an ex parte hearing on the matter, and is to grant access to the record upon a showing that information contained in the sealed record may be of assistance to the attorney's client.
Michelle, before we can move back
Sure.
one section to the inquest language, I think there is some concern slash confusion about the phrase of an inquest. And I'm wondering if there will be the same effect if we just make the requirement of filing an affidavit to the court in which they are showing that there's reasonable suspicion, and then the judge, almost like a warrant, I guess, making an application with the affidavit saying we have reasonable suspicion.
So same standard.
Yeah, same thing. Just think that it is not quite an inquest,
Okay,
what we're proposing.
sure. Okay, sorry. Sure, change that.
Thank you.
Sure. And then after the provision with regard to the defense, top of page 26, subdivision 3, is that a law enforcement officer can access a sealed record under exigent circumstances, and then for purposes of this particular provision, exigent circumstances means a compelling need to act swiftly to prevent imminent danger to life or serious damage to property, to prevent the imminent destruction of evidence, or to prevent the suspect from fleeing. If someone has a concern that the sealed record was accessed improperly, then they can file with the Vermont Criminal Justice Council.
Can I ask if that complaint is substantiated, what is the penalty? Are those laid out, or is it at the will?
I would have to look at that. I don't. So if you mean like how would they treat it? You do have a penalty, and I can add something in there about in addition to any, because there is a provision in law that if you access it without authorization, there's I think it's a civil penalty of up to $1,000, and I can cross-reference that if you want to be clear that that applies.
I don't think it hurts. In my opinion.
This reading something about exigent circumstances. Can you run
Oh,
that
I
back
was
more?
just asking if a complaint is filed about an improper accessing of a record and it's substantiated, what are the penalties? And so Michelle was talking about existing penalty in law and what it would be, and then just bringing that language into this cross-reference.
I think that may also be contained in what was initially proposed with the statewide policy idea. There might be some language that's also applicable.
Yeah.
Because I think there should be some sort of teeth to misuse of the exigent circumstance exception.
And I think in the crash and burn bill from last year, we have that.
And you passed that. I think it was actually a couple years ago.
Yeah.
There's been a lot of crashes
Yeah,
over the years, and you do have I'm just checking. I think it's $1,000 civil. Yep.
okay.
Well, I will say, so the unauthorized disclosure. State or municipal employee or contractor or any agent of the court, including an attorney, the employee or contract of the attorney who knowingly accesses or discloses sealed criminal history record. So certain law enforcement office, I guess what they. Is there anybody who would be law enforcement who would fall under that as a state or municipal employee, county sheriffs?
Yeah, So they would fall under-
Law enforcement.
yeah. But would they have access?
Well, if they're certified law enforcement officer, you're giving them access.
We could just say, or any certified law.
I mean, I can do an amendment to section 611.
What section are you talking about here?
So, under existing law,
Yeah.
there is a civil penalty
Mhm.
for unauthorized, accessing or disclosing criminal history records. And I don't think that the language that's in the current statute necessarily would capture all Leos who might be accessing the records. So what Senator Booth is saying is that, you know, there should be some kind of response. And they should be liable for potential civil penalty under this statute if they have been found by the Criminal Justice Council.
Well, I think that reverts back to there's only one police academy in the state of Vermont, so all law enforcement officers, depending on whether they're state, county, even constables now have to go through part-time programs, so they have to be certified through the Vermont Criminal Justice Training Council, along with any access to computers, whatever else.
Right, I'm just saying that the underlying statute doesn't mention law enforcement officer. It talks about state or municipal employee. So that would capture, I think, most law enforcement, but not all law enforcement. So you could add law enforcement to the underlying statute.
Senator Bowles.
Are we good on that? I'm gonna change the subject. Okay. I'm curious in the exigent circumstances, a compelling need, compelling to who? What does that mean? Just legally speaking.
That comes from State versus Murphy, which is the 2023 case. And I think it would be compelling to the police officer, I would suppose.
Right, and so then the judicial officer or the training council, whatever, will assess whether or not it's compelling is pretty high standard.
Yeah. I think the highest.
Yeah, you couldn't choose otherwise. It's,
Okay. Is everybody okay in general? So what I'll do is I'll tweak the language on 2A around the affidavit for reasonable suspicion. I'll add in the cross-reference in subdivision 3. And then I'll add a new section that amends and adds law enforcement to 27611 with regard to unauthorized access. Is that good? How fast we read that section. Page 27, line 8, just striking through the old language around the 10-year limitation. Subdivision 11, this is the same changes are made in 11 and 12, and this is on DCF and Dale's records. And this is just language that Judge Zone had recommended, clarifying that the DCF records are not case records and are considered department records. And then he also made a suggestion that rather than saying in response to a lawful discovery order, he said just next piece is on page 30. And so this is on the section with regard to the 18 to 21-year-olds. And the decision was to, because currently they're expunged, the decision was to have them sealed. And then I just restructured the section a little bit, I think, to make it a little easier to follow. So if you see the new language starting on line 14 on page 31, person who's 18 to 21 years of age at the time they commit the offense or qualifying crime, they can file a petition requesting sealing of the record after 30 days have elapsed since they completed the terms and conditions of their sentence. So they're getting kind of like fast track. They don't have to follow those other timelines that are earlier in the bill. They're to grant the petition according to if they meet the standards that are top of page 32, and those are the same ones that we have earlier with regard to or that you paid in restitution, and that the respondent has failed to show that seal be contrary to the And then subdivision.
I have a quick question. There was concern about, and I just need to know for sure now. First sentence is 18 to 21-year-olds. It just applies to the 18 to 21-year-olds, no other offenders in reference to the,
Deferreds are another section.
another
That's
section.
that's a separate section. That's,
18 and 21-year-olds.
this is just,
Every.
yes. Yep.
Except for specific conditions.
So it's just 18 to 21 we're talking about right now. Then. Yeah.
Yes.
Thank you.
And it still has to be a qualifying crime. And it just means that they have kind of a shorter time period in which they can petition to have the record sealed. But the standards are the same. The crimes for which they could seek, sealing would be the same. And currently for those 18 to 21-year-olds, those records are expunged.
But also currently they have to wait a number of years before they can do it.
Nope.
So
Just
how are we fast tracking it if they're already fast?
I just mean compared to what you have
Yeah.
for people who are outside of that time period. You're not changing the timeline
Yeah.
from the existing law.
And the deferreds, you just reinstated
Right.
all of the existing statute.
That will go from deferreds now. That's on page 34. And it didn't, this just is staying current law. So there's no change to deferreds. So they're expunged now and they would continue to be expunged.
This is the section where it's referred only to 18 to 21-year-olds. I get confused in states. So the first sentences still are going to exist, but it's for everybody.
Yeah, we're not touching deferreds.
Okay.
It applies to everybody. Court can order deferred for someone of any age. Those records, once someone has successfully completed their deferred sentence, those records are expunged and you're not making any changes to that.
For the qualifying offenses.
No, it has nothing to do with qualifying offenses.
The deferred sentence can be used for just about anything if the state's attorney wants to do that. So, there are certain offenses that the court can't impose a deferred sentence on, but the state's attorney can say, like for a domestic assault, for example, if the state's attorney thinks that somebody will do well with a deferred sentence, the domestic assault, they can make that offer in a plea negotiation.
So this has to come out to request of the state, is what you're saying? Or
Yeah.
Okay. All right. I'm going to do that then. Okay.
You can see also on page 35, just in the existing law, subsection C notes the types of offenses that are not, can't even be considered deferred sentences. And I think that's it. Yeah.
So pretty good.
Committee thoughts?
Like here from Judge Zonay about petition with sealing for things that are no longer the right.
Is he not? I'm assuming he hasn't provided any information.
No, I have to give me that one, but I haven't seen them on the schedule.
Senator,
If we're gonna have another round of testimony on a final or semifinal, I wouldn't mind hearing from Matt Valeria again. I know deferreds were the thing he was centered on, but he had a number of other concerns. Just like to hear about one more time if you. I mean, I assume the deferred piece will be gone for him, but like I said, if we're doing another, couple of witnesses.
Yes.
Thank you.
We also cut Marshall Paul off and told him he could come back.
yeah, I spoke to him over the weekend about defense attorney access. He voiced that he didn't really need to come in if we were making that change. So, go ahead, but
I like the ex parte positions and they, and the exigent circumstance. Those things take away a lot of my concerns about Proper access, and we've gotten rid of the both yard sections of, and looks good to me.
Yeah, my understanding was, Judge Selmy was going to find information for you and let you know about conditionless ceiling. Or did I misunderstand? Does he have information and you're just waiting for an invite?
I don't know. I haven't heard from him. But I still stand in a place that asking someone to be tracking everything we do in this building to know what's a crime and what they, if it's not a crime anymore, they should have a record, and it should be on the people who know the courts, the judges, to say, this isn't a crime anymore, we're erasing the record. Like, I feel pretty strongly that this should be petitionless.
Sir?
And we've had this discussion. I don't oppose that. But we also mutually agreed upon that we're not ready for that right now in the state of Vermont.
Not for petitionless across the board.
Right.
This is for one small piece. The report Judge Zone put forward that put all the resources that would be needed to move to petitionless was assuming that we were going to move to a completely petitionless ceiling system. This is one aspect that is only for things that are not a crime, not the whole system.
And didn't they do petitionless ceiling for, or even expungement for marijuana crimes?
Yes, they did.
So I'm just wondering what the outstanding bank of offenses would be. Michelle, do you have a sense? Like, if we were going to make it petitionless for things that are no longer a crime, what comes to mind for me, obviously, is cannabis. But are there other large fields of offenses that we've made non-offenses?
I'm not really the one to ask. What my concern would be around that there have been a lot of things that have been decriminalized and moved to judicial bureau. You know, so somebody would have to go down the list of all the things that are within the jurisdiction of judicial bureau, track back to what their predecessor offenses were. Were they crimes that people could be convicted in criminal division and have on their record now? Come up with, you know, like I think you need, I don't know, crime research, but you know, you need somebody to do kind of like a wholesale kind of look at trying to come up with those, and then you have to try to figure out, well, were there other things that were just
So this is
eliminated?
Sears would have said, let the sentencing commission do this, right? Go through and figure out the classes of offense and then bring us back a sort of digestible.
Sure. I mean, I don't know. It seems to me like there's a lot of research that would have to be done, but I don't know. You'd want to talk to the folks who would, you know, be the ones who have those records, go back and figure out what those be. You know, I think the Judicial Bureau jurisdiction is a good place to start to track things back. But
And my hope would not be that we would go backwards instantaneously, but that we'd give a pretty good runway, but that this would also apply going forward. So if we change laws and make things no longer a crime, we're not relying on the public to be following all of that and know, oh, I can now go get my petition or my record released, but that as part of the process of decriminalizing or making things that are currently crimes not crimes, it would go forward as cannabis did, and those records would automatically become expunged. It's not only retroactive, but proactively looking forward as well. I feel sort of more strongly about the looking forward.
It's like second time in our church, so I'm justify.
Wait to hear that. Any further? Okay.
So what I'll do is I'll make these changes. This hasn't been edited. I'll make these changes. I'll send it through editing, and then I'll get a copy to Kayla so that you guys have, you know, as close as you can, then you can still take your testimony, but or at least be close to a clean draft. And then just a little note is that I kept deferreds in here just so you could kind of see your policy change from ceiling back to the original, the way that it is now, but because I'm not making changes to that section, deferreds will just disappear off the next draft, so they won't be in here.
Thank you. Judge Sone is on his way and sorry, is there anything further? Okay. Maybe we can take 10, Judge Sone has to go to House Judiciary at 10:30. Then we can come back in 10 minutes. I imagine we'll be here by then. We can-